Help! I want to sell the real estate, but I need a court order. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine the petition for approval of sale of real estate when used in a deceased probate estate. This form is not for conservatorship or guardianship files, but specifically for the deceased probate estate in which the personal representative wants to sell the real estate. It is a SCAO form, State Court Administrative Order, Form PC 681. PC stands for Probate Court. Happy to provide the form free of charge to you, or of course you can Google it. Now this form is created by statutes and court rules. As you can see from the floating arrow at the bottom, it's pointing to the various statutes. Now you, of course, can review those statutes and should review them, as well as the court rules, to understand when and how to use the form. And most importantly, I would urge you to work with a competent, skilled probate practitioner before you even embark on the process of trying to fill it out. These statutes provide for the use of this form, and in certain contexts, you don't need to go to the probate court and ask for the authority to sell real estate. So for example, in an unsupervised proceeding in which there are no restrictions on your letters of authority, you have the legal authority under statute to list the property for sale and then ultimately sell it. On the other hand, there are times that the estate is either supervised or there are restrictions on the letters of authority, or even without the restrictions, you want to get the approval of the court to ensure that the sale price is appropriate, that there'll be no problems because you've got the issue adjudicated before the court. So this form, this SCAO form, is used to present to the court the nature of the sale, the terms of the sale, so that all of the interested parties that are going to be affected by it, that are entitled to notice under the court rules, are able to object, and then of course that the court can rule on it and impose a court order or even a surety bond if necessary to approve the sale moving forward. So let's walk our way through the form itself. The petition, which is the request of the court, is started off by filing it with the case number as well as the county in the blue. And when you do this, you fill this form out and then ultimately you pay a filing fee and it gets scheduled for hearing. At the top, you'll identify the name of the deceased estate and that you're the personal representative. And the next piece is that what are you trying to sell? And typically, people will include not just the legal description, but often the commonly known as address and any other details that may be sold with the real estate. You're going to identify for the purpose of, and it's usually for the liquidation of that asset, and then the identification of who is the purchaser or purchasers, and it could be a person or an entity, and it may even be a family member or somebody that's part of the probate estate. You're going to identify the amount of the sale price and the following terms. Now, in this particular case, the terms and conditions are required under the court rule, but often people and it is recommended and usually required by the court to attach the purchase agreement and any addendums to the sale to the petition itself, so that the court and the interested parties not only understand the terms as written on this document, but can read the entire purchase agreement to understand all of the terms and conditions and addendums that may exist. Further down, it identifies that you have included a copy of the most recent assessor statement or tax statement showing the state equalized value. And if you're not familiar with this, that can be obtained from the county assessor's office. It's on your tax bill. You take the number 2 times the state equalized value, and that shows the court that at least some reference point about the valuation of the property. It may not be an accurate valuation, but at least it's a starting point, and that's one of the requirements under the court rule MCR 5.207. You could also attach an appraisal that may be of value if, for example, if the sale price may be under scrutiny by the interested parties, or you want to show to the court the reason you're selling it for that particular amount. You're going to identify the outstanding mortgage, any property taxes or other assessments or expenses or liens that are incurred or encumbered with the property or a part of it. The next part is your assertion as the personal representative that it's in the best interest of the estate to sell the property for the following reasons. And it may be that you're selling it to maximize the estate value, to liquidate it. It may be to sell it to one of the family members for purposes of, maybe they're living there and you've got an agreement to sell to them. But the basis for it, or additional information to explain what's going on, would be referenced there. In addition, the court wants to know about the value of other assets and other real property. So for example, if you did an inventory earlier on, this would be an understanding for the court to understand that not only is this real estate being sold, but there may be other assets involved. In addition, it identifies any of the unpaid debts and taxes so that the court understands the creditor position relating to the estate. So for example, the reason the court may want to know this is that if it's being sold for X dollars, what may be available after the payment of creditors? How much risk is there to the estate? Is this a good sale price to address the needs of the creditors as well as the other parties? And most importantly, it's the bonding requirement. And a bond is a guarantee of performance. A surety bond is a requirement that is imposed by the court to ensure that the monies that will be received from the sale of the real estate or other assets is not going to be lost, and that it's going to be guaranteed that it's going to be administered correctly. Because if you fail to perform your duties as personal representative, there can be a surcharge on that bond. They can go after the bond because it's a guarantee of performance. They can go after you and, of course, the surety company. So giving this holistic understanding to the probate court judge and to the interested parties allows the judge to identify if there's already a bond, does the bond need to be increased, does there need to be a bond. Section 5 identifies an update to the interested persons. Remember, when you filed the original petition or application, the information is often repeated each time you file documents. They want to know, are there any changes to the interested persons so that the information can be kept current. Now, below the line, even though there's page 2 to this document, this is for the court to identify if there's going to be a bond and what the bonding amount will be set at. You don't sign there. That's for the court to do so, but that's the little notation piece for the judge to identify if there's going to be a surety bond. Now, to understand what this means, if the court says, yes, we're approving the sale, but it's subject to the surety bond being obtained, that means that before the order gets entered, before you can proceed to sell, you have to get a surety bond and go through a bonding agency to do so. And again, very complicated steps here for many people. Often the surety companies are going to require that you have a lawyer that's working with you on the file to be assured that these steps are done correctly. But this is a typical requirement for purposes of the sale of real estate. On the back side, you'll see that you're just simply asking the court to allow for the sale of the real estate and whether there is a bond that is required. There's a spot for you to date it, sign it, and if there's an attorney, that information would also be included there. Now, with all of these documents, there's a penalty of perjury clause that says that you are signing that document under the penalties of perjury, that's true to your best of your information, knowledge, or belief. So you fill out this form, you attach the requisite additional exhibits to this, you file it with the probate court, you pay the filing fee, you get a hearing date, you serve it upon the interested parties, and then you have your hearing for purposes of presenting the basis for the sale. I hope that this gives you a full understanding of the petition for sale of real estate, although there are lots of little nuances here. We strongly urge you to work with a probate practitioner when selling real estate. At the Probate Pro, we're passionate about everything probate. If you have questions about this particular process, the petition for sale of real estate, or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.